everybody. I'm opening the floor for the 4th International Seminar on AI and Law from the University of São Paulo. In this meeting, we will have Enrico Francesconi from the University of Florence, Monica Palmirani from the University of Bologna, Adam Wyner from the University of Swansea, UK, and Burkhard Schafer from the University of Edimburgo. They are all specialists and important researchers in their respective field on AI and law. I'll make a more detailed presentation at each moment. And I would like just in this beginning to emphasize that this is a pre-event for the ICAIL 2021, which is the main international research conference on AI and law, and that will be hosted by the University of São Paulo Law School this year. It will happen from June the 21th to June the 25th. And the registration is free, and you may find instructions for the registration in the Logarithm website, which is www.logarithm.com.br. So without further words, I would like to introduce you to Enrico Francesconi. Enrico Francesconi is Research Director at the National Research Council of Italy and Policy Officer at the European Parliament. He's also Professor of Information Retrieval and Semantic Web Technologies at the University of Florence. He's President and member of the Executive Committee of the International Association for Artificial Intelligence and Law. His main interests include semantic web technologies for the legal domain, legal ontologies and knowledge representation, AI techniques for legal document classification and knowledge extraction, e-government, and e-participation. So it's really a pleasure to have you and an honor to have you here, Enrico, in this seminar. And the floor is yours.
So thank you very much, Juliano, and thanks to all the staff of the University of São Paulo for your kind invitation to this very interesting and important event. I will share my presentation now. I hope that you can see it. So Professor Maranhão asked me to give a short introduction to the AI and law topics, and in particular to the activities of our association, which is the International Association for AI and Law. So I focus my presentation to these two main points. So it's definitely well known that the current information society is characterized by keywords like semantic web, linked open data, smart data, ontologies, natural language processing, and in particular about artificial intelligence, which is affecting the most part of our activities and area of interest, starting from the economy, the healthcare system, the public administration, and also in particular the law. And the combination of AI and law is something that comes from afar. Effectively, the law, we can say that is made of rules and interprets and creates facts. And similarly, the Turing machine, so basically the computer, is able to process facts in the form of data using specific rules encoded in different formats. And it does it according to two main paradigms. We can say that, first of all, the symbolic paradigm, in which basically rules are expressed by symbols, and the processing of data and the reasoning of the computer is made of a collection of rules and algorithms, and examples of this kind of paradigm is basically implemented in expert systems. And another paradigm is the so-called subsymbolic paradigm, or the connectionist model, where rules are encoded as a combination of elementary processing structures. And this paradigm is characterized by learning by examples. And an example of this kind of paradigm we can find in neural networks according to different variation that we can find in the literature. Now, we can say that the International Association for Artificial Intelligence and Law was born actually to deal with this kind of interest. So with the aim to support, develop, and promote the field of AI and law in the international level. And the main goal of the association is to organize a biannual international conference of artificial intelligence and law, which this year is basically organized by University of São Paulo. And the first ICAIL conference was organized in 1987 in Boston, and more recently at the National Research Council in Rome, at the University of San Diego, at the King's College in London, the Cyber Justice Laboratory of the University of Montreal in 2019, and this year, as I said, at the University of São Paulo, unfortunately only online due to the pandemic, but with additional challenges and opportunities at the end to have a wider audience. You can find the main information about the association, the official website, and here you can find the address where basically the main information about all the activities are reported. In the last years, we had several presidents of the association, starting from Thor McCarthy in 1992-93, and then Marek Sergot, Edwina Riesland, Anya Oskamp, Kevin Ashley at the University of Pittsburgh. In particular, I would like to underline that Kevin recently has published an interesting book on, which is an interesting introduction to the AI law topics. Trevor Bench-Capon, Carl Branting, coming from the industry, so not only academics, Tom Gordon, Henry Praken, Giovanni Sartor, Ralph Winkels, Jack Conrad, also coming from the industry, Katie Atkinson, and finally Bart Verhey of the University of Groningen. And in the last 2 years, I have the honor of chairing the executive committee of the association with Floris Bax, Michael Araskiewicz, Daniel Boursier, Monica Palmirani, Juliano Maranhão, and Dave Lewis. So our goal is actually to coordinate the activity of the association, and in particular to organize the main event, which is the ICAIL 2021. As for the topics that let's say the activities that are carried out by all the scholars, let's say the researchers in our environment, we can say that the topics of artificial intelligence and law and the research in this field have been moved by two distinct motivations. One is a practical motivation, and the other is a theoretical one, as Thor McCarthy used to say in an interesting paper of his in 1990. In particular, the theoretical motivation has the objective of gain a better understanding of the process of legal reasoning and legal argumentation using computational models and techniques. On the other hand, the practical motivation aims to build intelligent legal information system supporting legal practitioners and decision makers and citizens. Let's see let's have a look at some scenarios that let's say focus the attention on the interest topics which basically our community is dealing with. The first scenario is the one that I have called the information retrieval scenario. Let's consider a user that who wants to subscribe an online contract. He might be willing to know more about the consumer protection law, and in particular, he might be interested in consumers' rights, for example, the right of withdrawal, or the supplier's duties towards the consumers, which are basically implicit rights of the consumer himself, or the procedure to fulfill the consumer's duties and the sanction in case of not compliance. Now, nowadays, there are no search engine or retrieval system or processing systems able to respond to this interest. So what we need is a legal information retrieval system endowed with reasoning facilities. And the scenario is made more complex, for example, considering the multilingual environment, for example, which we have in the European Union, but also if you consider a sort of federative approach in processing legal information over the internet, what you need is a unique point of access to resources in a distributed environment. So having an advanced legal information and retrieval system endowed with reasoning services, able to respond to queries, complex queries like which version of the Directive 2003/98 EC adopted in November 2003 was in force in June 2013, or another complex query, in the country X, which law is applicable to divorce of cross-border couples, or which national laws on consumer protection do apply in a specific region, or let's say going in more semantic-oriented interest, which are the rights of the consumer according to the EU law, or which are the implicit rights of the consumer according to the EU law. As we said before, these are complex inquiries that cannot be solved, cannot be addressed in an effective way by the current system, in particular search engine system, even advanced, because what you need is actually retrieval and reasoning, advanced retrieval and reasoning services dealing with legal information. Another scenario, the one that I called the legal compliance scenario. Let's consider you want to detect, I have a system which is able to automatically detect the speed limits according to speed limits regulation. You might be interested in checking drivers' compliance with regulation about traffic speed, or checking such compliance in presence of conflicting rules or rules changing over time, what it is usually addressed in literature as norm defeasibility. Also in this case, you need systems able to implement compliance checking of rules, of legal rules endowed with reasoning facilities. Another scenario, the third scenario, which I called a legal dispute scenario. Usually a trial can be conducted in a traditional way based on rules, precedents, and the dialogues between and among parties. But in the current information scenario, information system, information environment, the users might be willing to go with alternative dispute resolution services supported by digital tools. And in this scenario, what is important is to have the possibility to transform the general theory of argumentation in a way which is amenable for computation, like let's say having a let's say, models for dialogues between parties, or models able to analyze rules and precedents in an effective way. That's why in this scenario, we used to address the problem in terms of applying computational argumentation in law. And this is one of the main topics that is addressed by the literature in the field of AI and law. These are the topics of ICAIL 2021, which basically detailed more the scenario which I have talked before. For example, argument mining for legal text, or automatic extraction of information from legal databases or legal text like legislation or case law or administrative acts, or let's say ethical aspect of AI and law, or let's say modeling norms, or modeling legal knowledge and legal knowledge representation, and finally open and linked data in the legal domain. In particular, one of the most important environment of interest for the AI and law community is actually the semantic web, also called in literature like Web 3.0, Web of Data, or Internet of Things, which are basically more or less synonyms. The semantic web is important because it's actually an evolution of the internet has and that the web has we have as we have considered so far, where the information is understandable not only by humans but processable and understandable also by machines, in order to have as objective the technological, semantic, and multilingual interoperability between information systems, and having the possibility to develop advanced access service. So basically, it's let's say you can understand how this scenario can be of interest for implemented advanced services, also for the legal domain and for providing legal information systems over the web. And in particular, in the last few years, a great promotion to the semantic web has been given by the so-called linked data movement, which are structured and correlated data on the web, or the also called linked open data movement, where we address linked data in terms of data published on the web with open licenses. So basically, the semantic web is made of linked open data. The semantic web is the whole, while the linked open data is the part. And an important boost has been given by the so-called 5-star rating schemes for linked open data, coming from a very famous article written by Tim Berners-Lee, who is the creator of the web, providing basically a ranking related to the quality of data at higher degree of complexity, which can be published over the web. Why it's important, the semantic web in the legal domain? Because the combination of the semantic web standards and the linked open data, so the availability of data, processable data by machine, allows you to have the possibility to transform the law as a code. So having legal information processable not only by humans, but also by machine for creating advanced legal information systems. And about these very topics, in the next talk, Monica Palmirani of the University of Bologna will be addressing this aspect about legal markup languages, legal rule ML, and challenges of computable law. Similarly, Adam Wyner will address another scenario that we have discussed before. So providing an introduction to argumentation systems. And finally, Burkhard Schafer of the University of Edinburgh will talk about ethics and the law of AI, which is a very important topic, considering also the recent interest of the European Commission in the ethic aspect of AI has applied to several domains, including the domain of the law. So enjoy the next talk, and thank you very much for your attention.
Thank you very much, Enrico, for your talk. Before we proceed, I would like to emphasize and thank our sponsors for this event and the ICAIL event. We have as sponsors the Use Brazil, which is a search engine for legal documents and jurisprudence. Urbano Vitalino Advogados, Legal Code, is a law tech, and Logarithm, which is the Institute of Research on AI and Law. So thank you very much for our sponsors, and I will move forward now with a question to you, Enrico. I would like to know, within these scenarios that you have displayed, what do you see currently and nowadays as the biggest desideratum, if there is not only one or two or three biggest desideratum and challenges, which are the breakthroughs that we are searching in the research on AI and law nowadays?
Yeah, actually, in the legal domain, we are facing problems which are more or less similar to the challenges that we had in the early past in the internet. For example, implementing services, search and retrieval services for legal information is one of the main challenges, and is still one of the main challenges. Giving the user the possibility to retrieve legal information in an effective way, and improving precision and recall, and having the possibility to search not only documents, but in particular norms, so legal provisions, basically. And having the possibility to implement reasoning services that allows you to detect, let's say, advanced or technical or more precise information about legal matters. This, I think, it's an important step because, let's say, search engines are the most famous services over the internet, and still users, like, for example, legal practitioners, are looking for services like the one I mentioned. But not only this type of services, everything that can be conceived when you have the possibility to transform the law into code can be considered of interest for not only for let's say legal practitioners, but also for example, policymakers. You have let's say the possibility to implement advanced services for the final users. So legal, artificial legal advisors, for example, the possibility to go with alternative dispute resolution services, And everything is possible if you have the possibility to transform the law into a machine-readable format, and in a format which is amenable for computation. So I think that basically this is one of the main area of interest. That's why I think, for example, that the implementation of the semantic web theories and practice in the law is still probably one and probably the main challenge in our discipline. On the other hand, just two words also about the problem of legal argumentation, which is another very important aspect, which comes mainly from the so-called theoretical motivation. It's also a very interesting part because it is able to address the two different modality to deal with legal stuff. So the common law or civil law approach to the resolution of disputes, and in this respect, having the possibility to implement automatic agents able to deal with this scenario, these approaches, it's an important step, which basically allows you to study the let's say the theoretical part of argumentation and to implement it in a concrete cases.
Sorry, thank you, Enrico. There is another question here. You have talked about symbolic and sub-symbolic methodologies, and the question is about the landscape of the research community nowadays, whether there are the research spends more energy on knowledge representation systems or on machine learning systems or data systems, and at ICAIL, what is the landscape nowadays?
I would say that it's a combination of the two approaches. You can say that there is a sort of a top-down approach, mainly devoted to the representation of legal knowledge in terms of ontologies, for example, legal knowledge models, and the bottom-up approach, more oriented to extract knowledge from legal text and to map this information to knowledge models. Let's say they are, I would say, complementary. And in our community, let's say we have more or less the same interest to both of the approaches. Just because they are actually the same, the two faces of the same reality. From the one hand, if you are more interested in information retrieval, probably you are more interested in a bottom-up approach, because you want to extract knowledge, you want to detect specific keywords, having a classification of legal materials from the bottom. On the other hand, if you are more interested in the implementation, in the automatic implementation of a legal reasoning framework, I don't know, like for example, Opheldian reasoning or legal compliance or reasoning, and so on, you are more interested in implementing knowledge models using ontologies or other similar schema. But nowadays, the implementation of ontologies, since it address the effective implementation, the actual implementation of the semantic web, it's of particular interest by researchers.
Perfect, Enrico. Thank you very much, and congratulations for your talk and the discussion. It was very insightful. So without further discussion, I would like to introduce now Monica Palmirani. She is professor of computer science and law at Bologna University. She graduated in mathematics and holds a PhD in legal informatics and IT law. Her main interests include legislative and legal informatics, in particular XML techniques for modeling legal documents, both in structural and legal knowledge aspects, so, and also including normative rules. Monica, you have the floor now. Thank you very much for your participation and contribution to this seminar.
Thank you to you, Juliano. Thank you very much for the invitation. It's a great honor to be here, and welcome to everybody. So the main topic of my talk is concerning the serialization of the knowledge in using legal XML standards, but I want also to have a little introduction concerning the meaning of the serialization of the legal document in general. So let me recall a little bit the history that we conducted in the last decades. We started with the goal to serialize the legal document, especially legislation, with the goal to have open access in internet and to permit transparency and accessibility to the law. And so we dedicated a lot of energy in this task to serialize and open for everybody the law and the case law. But during this task performance, we discovered that we can also manage a lot of data. So we discovered a lot of knowledge included inside of the legislation, the case law, as Enrico Francesconi said before, very useful for putting evidence, for managing the reasoning on the top, and open data and linked open data combined with the semantic web became a big goal to perceive and to go ahead in this direction. But another topic was also very important to extend these technologies from the single step of a publication to all the steps of the workflow and the lawmaking system. So we assisted to the idea to create natively in digital way the legislation annotated in XML, but also with semantic web annotation. And thanks to the creation of bigger corpora annotated in the past decades, nowadays we are capable to cope with other important challenging goals, like to apply the huge amount of theory emerged in the last decades of concerning artificial intelligence, but now we can apply in concrete manner because we prepared before the corpora and the material for applying the theoretical aspect performed before. So now we are in the era where artificial intelligence and also smart contracts, machine consumable law and case law is not only an academic goal, but are both a very concrete part of some parliaments or some tribunals. There are a lot of important principles that we needed to maintain: the provenance, integrity, authenticity of a legal source, and other important principles and pillars like long-term preservation. So in the digitalization of the legislation and the case law, we need to pay attention also to the next generation in order to make reusable this material, and with a clear separation between the content approved by the parliament or by the authority, the metadata added on the top by by different actors. And finally, the presentation instructions that the media or the devices include inside of these serialization. This is extremely important. Also, the workflow and traceability of the lawmaking process is a very important goal for maintaining transparent the lawmaking system. But nowadays there is an emerging new keyword, rule as a code, that has the aim to make the law and the legislation natively provided in code. So starting not by the language, not by the legal language, that is a long tradition and also based on a theoretical aspect like philosophy of law, but theory of law. But the idea is to model the law first as a code to check the consistency and the logic point of view, and then to transform in text. So this is a project that is now conducted in New Zealand, but also in Australia and in other parts, like also in the US. But this methodology is quite risky from my point of view, but not limited to my point of view. Other experts said that we needed to include in this vision the long tradition of the legal language, interpretation, argumentation. And so finally, it's a good approach to see that especially the parliament started to consider seriously the serialization of the legislation in machine consumable. But in the meantime, we need to recall all the results coming from the artificial intelligence and law community. And we have a big result to share and to include in this vision, especially in the cycle of dialogue between the human and the machine, so-called principle human in the loop. So I think the two visions are not in contrast, but could be integrated, and especially because the temptation is to jump from the idea immediately to the code and to transform the code in text, creating what is called as a black box. So I have a text and I jumping immediately in artificial intelligence output, and I'm not able to justify the process, the life cycle, what happened, why, and which technology used. So this is a topic very important, called the explicability of the artificial intelligence. And using rule as a code as is, without integration with the artificial intelligence results, it is possible to have this risk. For this reason, our approach is different. We suggest to start from the text elaborated by the legal expert, using legal tradition and legal language to transform step by step in a serialization, machine consumable, annotated with the semantics, as Enrico mentioned before, and then to pass to the logic representation with the simplified legal language. And then when we are so much confident of the robustness of these translations step by step, we can proceed to transform in logic formula. And finally, if you want, also in smart contract, immediately consumable and executable by the machine without intermediation of the human being. And finally, the presentation for the human. So this is our approach to track all these paths with some standards, with some principle, in order to have a transparent process. This is our approach to have the document serialized in XML, combined with the different legal ontologies in the community, and also to have a serialization of the text in logic formula, combined with the ontology that can express the legal concept and the relationship between the legal concept. Obviously, all the processes should be certified by authority, like a parliament or the Gazette. And when we are quite confident of the robustness of these, we can extract knowledge, serialized and linked open data, and we can combine with the rest of the knowledge available nowadays in the so-called cloud linked data, and we can combine with different other applications, geolocalization, or Internet of Things, or in case also with some reasoning engine that is capable to suggest something to the judge of the public administration. And why not? The same approach is good also for the smart contract. It's quite risky to jump from the legal contract test directly to the smart contract. We can mislead a lot of concepts, and this methodology is a good also for checking the consistencies of the relationship between the legal concepts. But machine learning is one of the trends nowadays in the legal domain and artificial intelligence and law. And some remarks or open questions are already on the table. Machine learning especially works on sentences, so level, not at the document level. So we need to integrate machine learning with other vision coming from the whole document. There is time to time a missing part concerning the context of the document, like jurisdiction or temporal parameters, because machine learning is very focused on the single sentence inside the paragraph, and the relationship with the other paragraph are quite ignored by definition of machine learning. But also an important part of the debate is that machine learning depends too much to the past data, and so new law that come inside of a legal system has less importance in terms of frequency or in terms of linking or citation, and so we need to include countermeasurement to these mechanism. And also citations, machine can't distinguish too much Article 3 from 13 because only one character is the difference. So machine learning can decide that Article 3 and 13 is very similar, but we know perfectly that the two articles can say something completely different. And also the temporal aspect inside of these projects, usually of machine learning, are neglected, and we know perfectly that the dynamicity of the legal system is super important. Just a case, in case law, obviously the case law based on repealed or abrogated norms could be managed in different manner respect the case law based on enforced law. But these are open questions that need some counter-measurement, and in our opinion, the pre-markup in legal XML in the semantic annotation can fill the gaps or can provide partially an answer to these questions. For this reason, in the last period, 10 years, we, inside of the community, we developed a lot of standards XML for annotating different level of knowledge concerning the legal document, starting from the URI, unique identifier, the document itself, metadata for enriching the information linked with the document, ontology level, and also the logic formula representation. And for this reason, inside of OASIS, that is an international standardization body, we started two groups, technical committees, one dedicated to XML legal docML or Accomatoso standard for modeling the document itself, and a second technical committee called Legal Rule ML for modeling norms, so the meaning exactly of the part included in the text. Accomatoso, it's an African word that means linked arts. Was founded in Africa thanks to the United Nations, but nowadays it's quite used in different countries in Europe, in US, in Brazil, and in other parts. Accomatoso is capable to manage different kind of document, and it's very flexible for any customization for legal system, for any legal systems. And one characteristic is to manage the metadata for tracking the lawmaking system and the workflow during the preparation of the bill and the transformation of the bill in act. And also to track the amendments and the modification over the time in order to support the consolidation and to offer the law point in time to the citizen. And the scenarios are many where Accomatoso is useful: drafting for supporting the civil servant during the legal drafting, to help to adapt and adopt ontologies, support the translation, especially multilingualism environment, and also to track the amendments, support the cooperative work between different bodies, chamber and senate, or inside of European bodies, the council, the parliament, and the commission. And another important aspect is that Accomatoso permits multiple visualization according to different devices. And now we are experimenting some artificial intelligence application and legal data analytics on the basis of big corpora that we have developed in the last 10 years. And we are now applying these techniques to the Italian legislation, but not limited to the legislation, also including case law. And these are some success story of application of Accomatoso, and I'm very happy to say that the Brazil Senate was the first that believes in Accomatoso and translated a partial subset of Accomatoso in Portuguese and Brazilian in order to apply to the case of the Senate of Brazil. This is a snippet of Accomatoso, quite easy also to read for the legal people, not the technical people. So we have a metadata in the top and the body that it is possible also to apply digital signature and multiple digital signature coming from different actors according to the power. But the second argument, the second, let me say, standard is about norms. So after the modelization of the document, we need to enter in deep of the meaning of the document, so the norms. And for this reason, we have developed, also thanks to other colleagues. One of them is Adam. Adam contributed a lot to the standard of legal ML. And what is the goal of legal ML? Is to model in XML standard the norms. So not simply the structure of a document, the citations, the temporal parameters, that is included as well inside of legal ML, but the most important part is the rules. So to transform the text in logic rules in order to permit for instance, compliance checking, or to detect anomalies inside of the document, or a bad reasoning inside of a case law. And one of the main characteristics of legal ML is the association of the original text with these rules in order to have a system traceable, and from the rule I can navigate the original text of the Gazette and vice versa. And another point is that we can model multiple version or so-called alternative of the same piece of text according to the different opinion of the scholars, of the judge, or the level of jurisdiction. So the same piece of text can have different interpretation at the European level, of Italian level, or a regional level. And all of them are equally valid depending to the jurisdiction. So the same piece of text admits or multiple rules interpretations. This is more or less how legal RLML looks like. There is a block of metadata, very similar to a Accomantoso. For this reason, we have a mapping directly with the Accomantoso in this part. And we have the rules in the bottom and a bridge part in green that connect the metadata with the rules. So the rules in the past expert system were modeled alone, without context, without temporal information. And now we can, thanks to these mechanisms, to combine metadata and context and the rules each other's. Additionally, the legal RULE-ML, because it is based on another standard called the RULE-ML, added specific deontic operators for facilitating the annotation of the norms. So we have operator for obligation, prohibition, permission, and so far, and also to connect each other the penalty with the obligation in order to detect immediately obligation and penalty connected. So this is quite interesting because we can make also a very complicated queries, but very useful for the legal domain. And also the feasibility. Obviously, we can have in law a main rule, but also exception of exception. And we have an easy way to define this situation inside of legal RULE-ML thanks to the operators of the feasibility. This is a little example. This is a fragment of a GDPR regulation. It's a regulation, a European regulation about privacy. The Article 80 talking about the child and the permission that the child should provide it to the information society services. And there is a limitation of the age, at least 16 years old. And we can model the text as is in Accomantoso, first of all, with all the metadata, with the references. And this is a very important structure for applying in the second step, the logic rule. So the first step is to transform this piece of text in Accomantoso. The second step is to model the logic rule. And we can also this is a legal RULE-ML transformed. So we have a connection with the Accomantoso thanks to some parts of the standard. So each rule is connected to the official Gazette part. And also with the ontology. So if I have a concept of personal data processing, I can connect a ontology already available, so it's not invented, but we have an ontology provided hopefully by a scholar or by the parliament. And this is ontology permits me to also detect new knowledge connected. So the child, he is connected with the parent responsibility holder, but is not written in the text. I can detect and infer thanks to the ontology. So the simple piece of text is enriched level by level in order to provide a safe analysis of the legal concept. And on the top of that, I can also manage exception. In this case, in Italy, is not 16 years old the limit, but 14, and in other countries 13. So we can define exception of the main rule country by country, jurisdiction by jurisdiction, without to duplicate the main rule, but only to intervene on the single part that is different country by country. We have also some tools developed in the domain. This is one proposal, but there are many, and the mature are quite, the age is quite mature, the technology is quite mature to apply in the concrete scenario. So the idea at the hand is to use legal XML for open the black box and to provide more levels of knowledge in order to track the process, the methodology for transforming the text legal binding in machine consumable, and to have also some methodology for maintaining the focus on the legal theory and the principle of the legal system. So from my point of view, we use a mixed artificial intelligence, symbolic, stochastic, and symbolic together. So my opinion, the emerging trend is to mix in a hybrid system all of them according to the goal. But on the top, I use serialization of the document in XML in order to provide the answer to the open question of the context, more information concerning citations, more information concerning the relationship between one paragraph to another, especially if they are connected by obligation and penalty, for instance. So this is my view, and I can conclude that XML in the background can help artificial intelligence to be more transparent and effective.
Thank you very much, Monica, for your brilliant and very clear, crystal clear presentation. We have a question from the audience, which is, in your opinion, how the GDPR and the laws regarding privacy would relate to these machine execution processes?
So there are many projects nowadays that have the topic of the GDPR in order to transform the main rules in machine consumable. Not obviously the principal part of the first chapter of the GDPR, because are very, very high level principle, and is too much interpretation, too much shadows of interpretation. But for some chapter in the final part of the GDPR, we find obligation for the controller or some obligation for other actors involved in the data processing. And the data protection impact assessment could be a lot of benefits if the rules of the GDPR are modeled in Legal ML. We have inside of Legal ML a repository where Livio Orbaldo attempted to model all the GDPR using Legal ML. Is a valid, in my opinion, example, and quite exhaustive. And the idea is to reuse this material to make check compliance. So, for instance, to understand if my privacy policy is compliant with the GDPR, if all the rules that are expected are included, or to transform this piece of text in icons, because the GDPR includes also this option. And so these is our little goals, but if we can apply to all the privacy policy, is very massive in terms of volume.
Thank you very much, Monica. Just to inform the Brazilian audience, in the logarithm, and there is a project and where we try to apply Livio about those methods and the Preco project to formalize and making to machine consumable the Brazilian data protection law.
It's a great project. So I contributed also because I cooperated with Livio Robaldo, and we have also the GDPR in Accomantoso available.
Great, and we are using the Pronto ontology also that you have developed with your team.
Yes, so we use a Pronto ontology. Pronto ontology is not released open nowadays because there are some evident mistakes that I know very well, and I'm fixing these. And I promise to open. We are building the portal, and before the summertime, we definitely will be ready to open Pronto. Pronto is quite a core ontology about data protection in general, starting from GDPR, but not limited to GDPR. It's based on ontology design patterns. So it's composed by modules, and each module could be customized according to a specific legal system. So it's not a very detailed ontology, is a core ontology, but the main blocks concerning temporal relationship or role agents and duty and the deontic operators are included. And I think it's a good starting point for developing something more concrete and more detailed.
Thank you very much, Monica. We now have 15 minutes of a break, a short break, and we come back with the streaming very soon. So thank you very much, and we come back soon. we are coming back for the second part of our seminar. I would like to thank again our sponsors, Jus Brasil, Legal Code, Urbano Vitalino Advogados, and Logarithm, who made this event possible. And we are now moving for the second part, which will begin with Professor Adam Wyner. He is an associate professor of law and computer science at Swansea University, UK. He holds a PhD in linguistics and computer science, and his main interests include knowledge extraction, representation and reasoning, natural language processing, argumentation, case-based reasoning, and machine learning. So Adam, please, you have the floor.
Great, thank you. It's a pleasure to be here. Thank you for the invitation. And I think it's a really good idea to have events like this. Just confirm that you can see my slides.
Yes, perfectly.
Perfect, great, thanks so much. So I was invited to speak about legal argumentation. I've done some work in this area and participated in some projects and some meetings and things like that. This will be a brief high-level fly-through about some aspects of legal argumentation. I realize that there are some things that I don't talk about in this slide stack. I might mention those very briefly, or people might ask questions about it. It's a certain aspect of legal argumentation. So we could really start off with Leibniz, who kind of introduced this idea about calculating over arguments. So the only way to rectify our reasonings is to make them as tangible as those of the mathematicians, so that we can find our error at a glance. And when there are disputes among persons, we can simply say, let us calculate without further ado to see who is right. And this statement from quite a while ago really sticks and is kind of an inspiration behind contemporary approaches to formalizing and representing legal arguments. So let's just talk about we'll talk about the general context, some formal approaches, and a short example of argument analysis. I'll also touch briefly on argumentation schemes, what they are, what they're used for. Talk about where are legal arguments, what's the use for the analysis, and how are they found. So what are legal arguments? People who are lawyers have some ideas about this. We can also broaden up this point of view from just legal arguments to arguments in general, but here we'll say some things about legal arguments. So we have legal arguments in legal cases where, for instance, you have a plaintiff and a defendant, and they have different sides in a legal dispute. Their lawyers are representing them, and each side is only representing their point of view against the other side's point of view, and vice versa. So it's an adversarial kind of context. The goal is to find one party guilty or find somebody else innocent or establish some kind of penalty. And over the course of the discussion, if you call it a discussion, but it's a debate or an argument, each side presents a range of legal arguments and evidence to support their particular position. So we might say briefly that an argument is simply a statement that's given some premises from which a conclusion follows. And we'll have another specific example of that shortly. Another place where we could talk about legal arguments are in policy consultations. So here, for instance, the government is interested in some kind of policy or taking some kind of action. Let's say they want to build a new airport, or they want to decide whether or not they should provide legislation to subsidize farmers, or what the position should be of the government in terms of providing funding for education and under what terms. So what the government does in some respects is they go out into the community and they have a list of, let's say, 10 or 15 kinds of questions that they want to have answered. They solicit answers to these questions in order to get public opinion, okay? And what they get in return are a whole stack of documents where different interested parties write their answers to the questions, and then the government will take all of these statements that are contributed by interested parties and try to do some analysis to identify what are the various positions that are held across this community, both for and against this particular proposal. And based on that, the drafters of a particular piece of legislation or proposal will form a white paper, which will then put forward a certain number of policy proposals and specific, and that then will go through a process which can then be transformed into a piece of legislation or drafted into some regulation. So as you can imagine, this is a very significant task to carry out because there are divergent opinions about what to do and why to do it, and what are the sort of underlying justifications or motivations for their particular points of view. So this is another context in which we could talk about arguments. And these are particularly legal arguments because they're in a legal context of drafting legislation regulation. Let me just add one other remark before I move on to this slide. Arguments are found all over the place. Anytime where there's a difference of opinion, or in a sense, anytime where you're trying to come to some decision about some matter, and there are some differences amongst the various parties about this decision, there could be some version of argument. An argument is not always an antagonistic discussion. You can also look at arguments where you're just trying to find out information in order to come to some common understanding of things. Another place where you could see arguments are, for instance, in consumer websites, where there's a discussion about what item to buy. And if you look, for instance, on Amazon, on the, about a particular consumer item, let's say a camera, you'll see on the, below that, there'll be a variety of comments that people contribute both for and against buying that camera. This too can be seen as argument, and this too can be seen as something that you would like to reconstruct in some structured manner. So what's the use for analysis? Well, we have legal cases which are very long and complicated, and they're very intricately, chained together. All the arguments are chained together. And what we can see here is that the information is distributed amongst various parties and distributed over various texts or various kinds of exchanges in the discussion. So there's this distribution problem. And what you would like is that for the various parties to have the opportunity to kind of reorganize and restructure all of that information in a coherent and cohesive manner so that they can really get a view into what it is that they're discussing and what it is that what are the reasons for coming to a conclusion. And the same thing is going on with policy consultations. And the same thing is going on for camera websites or consumer websites where there's a great deal of information that's distributed. Again, just put yourself in the shoes of wanting to buy something. You go onto Amazon, you're looking at a particular camera, and you find that there are 1,000 comments about that camera for and against in different respects. How many people bother to spend all the time to read through those 1,000 comments to figure out what it is that they want to do? Unlikely that anybody does, even though those thousands of comments could be very informative with respect to your decision, okay? So it would be nice to have a tool that will pull some of these things together. As I've mentioned, there may be various places where we find arguments. I've mentioned a couple of them already. And how do people kind of come to organize these arguments? Largely what's going on right now is that the methodologies for analyzing and organizing arguments are manual. That is, people will sit down together and say, okay, there's this point of the argument over here and that point of the argument there, and these 2 points are the same kinds of things, and they will manually reconstruct the argument. There's a great deal of work, I don't discuss this very much here, to try to apply natural language processing techniques on a corpus of argument statements in order to carry out this task of summarizing and reorganizing argument statements. So that's just a little bit about where arguments are found and a little bit about the purpose that might be given to reconstructing them, and a little bit about how natural language processing might be applied to reorganizing arguments. We can also talk about some of the formal analysis that's applied to arguments in order to sort of reconstruct the pattern of reasoning that we've got. So let's just first look at a little bit of an abstract about what an argument is. It's reasoning essentially from assumptions or premises to a conclusion. Here we have this reasoning pattern called modus ponens, where P is an assumption. If P arrow Q, that means if then, right, is a rule. And where you have these two assumptions, if that is P and the rule, you can conclude Q. Okay, you can in effect separate off Q as a conclusion. This standard rule that we know from propositional logic. We can call this reasoning pattern, modus ponens, an argument scheme. That is, it's a pattern of reasoning, and we will talk about some other patterns of reasoning later. This is set within a classic logic, that is propositional and predicate logic, that's known to be monotonic. That is, inferences that are once made cannot be withdrawn in the light of new information. An area where monotonic reasoning is extremely useful is in mathematics, right? Mathematics, once you sort of provide the proof, maybe there's an error in the proof, but you generally would sort of clean it up so that there are no errors in the proof. And then once it's done, and you constantly can build and add to this mathematical knowledge. So we talk about these inference rules as being strict. If the antecedents are true, the consequent must be true as well. And we don't add and remove rules. So that's what we generally do in classic logic. The problem is that legal reasoning is not like classical logic, because it's possible for inferences to change once new information is added. So you can have new evidence, you can have new source material, the legislation might change, there may be a change in legal argument. So there's this dynamic aspect of legal reasoning. For instance, as well, legal rules can become invalid, even though they remain on the books. They're invalid, they're inapplicable, right? And this is something that Monica has worked on in legal DocML, of annotating rules as being effective or ineffective. We also talk about legal rules as being defeasible. They hold in normative circumstances, but for instance, there may be rules that are said to hold, but so long as there are no exceptions, right? So that we know in reasoning about rules in the law that there are numerous exceptions that arise. And so, you can say a rule usually applies except if somebody has a particular status or something like that. Another instance is that rules may be arguable. That is, for instance, in the United States, there's a whole bunch of legislation about search and seizure. And there's an important difference between searching somebody's home, in which case you need to have a legal warrant and a justification for going into their home, versus search and seizure within a car, in which case it's understood that you don't need a warrant. And in a sense, a car is a much more public space. What do you do, though, when you have a mobile home, which kind of crosses over this boundary of being a car versus a private home? And there's a whole discussion about what rules apply there, and there has to be some argumentation about it. I mentioned already arguments. Another aspect of legal reasoning that's problematic for strict logic is that legal arguments can and often are contradictory. So in an adversarial setting in court, one side argues against the other, and both sides may just actually be calling one and the other a liar, right? Or saying the facts that are presented by one side are contradictory to the facts that are presented by the other side. The problem here is that we, as arguers, are able to sustain discussion even in the face of contradiction. Logic does not allow this. Logic will simply, in a sense, stall as soon as it gets to a contradictory setting. So this is a basic principle of classic logic that is simply not able to overcome. So one of the important aspects is to find some treatment of contradiction so that you don't simply stall further discussion. Another aspect of legal reasoning that we see is that there can be different proof standards. That is, a claim or a conclusion only needs to be demonstrated to a certain proof standard. So for example, in the United States, there's a difference between criminal and civil lawsuits, and they apply different standards. You can be, for instance, in a criminal suit, if you're accused of murder, you have to have it beyond reasonable doubt. but you can also take this to a civil context where there's only the preponderance of evidence that may hold in order to convict you of, let's say, manslaughter. About the same facts and the same crime, depending on the context, different proof standards may apply. Another aspect is that we find that different, if there may be two rules that apply, and yet there is rule prioritization. And we'll take a look at this a little bit later, but one of these is lex superiori, where laws that are promulgated from superior courts trump rules that are promulgated by subordinate courts. So even though the two rules hold, there's a kind of a dominance relationship between the rules. So there's this whole space of problems with legal reasoning that are beyond the scope of classical logic. So to address this, there's a whole approach about computational models of argumentation. There's two basic levels of this. What I'll do is I'll say this very briefly, and then I'll give you a short example to show how this gets worked out. There's the abstract level, and then there's what's called the instantiated level. So the abstract level, which I will give you an illustration in a moment, is that we talk about arguments as being atomic objects, entities that are in attack relations. Again, I'll show you what this looks like in a picture shortly. We have a way of analyzing these kind of graphs of argument relationships to determine what are called extensions or sets. These are essentially sets of arguments that hold together, that are consistent, that don't have any contradiction. And this is what helps us abstractly reason in the face of inconsistency. Then we have what's called instantiated argumentation, where we have knowledge bases, that is, statements about the propositions that are true or the rules that are true. Modus ponens is one of these reasoning patterns, and we can have the P's and the Q's as propositions that are true or false. Here we can have argumentation schemes. We can introduce proof standards and various kinds of things like this, as well as a variety of modes of attacking different kinds of arguments in different forms. I'll illustrate these things, but there are these two separations. There are these two parts of this computational model of argumentation, but you'll see that they get connected shortly. So here's the example that I have, and it's about a dispute concerning whether or not it's appropriate in a driving. I hope that you can read this. I hope that I didn't make it too small. I can make it bigger if that helps, but let me know if that's too small to read. So here we're talking about autonomous vehicles. And we're talking in the United Kingdom, there's the highway code. Those are the rules of the road. That's what you need to learn in order to get your license, right? And there are a lot of instances of driving which are left up to your judgment to a certain extent. There may be a law that says you are not allowed to drive your car on a footpath. So that's sort of seen as an absolute rule. And then it says, except in certain circumstances, right? So it's prohibited to drive on the footpath, except if, and then there comes some exceptions, right? So when would there be an exception, and how would that work? Essentially, what you'd have to do is suppose that you're driving and a child runs out into the street, and you swerve out of the way and you drive up onto the footpath, the sidewalk, and then you're taken to court. You know, you're caught by the police and you're given a ticket for driving on the footpath. That's illegal. You go to the judge and you say, Your Honor, yes, I did drive on the footpath, but I'll tell you why I did it. And I believe that one of the legal exceptions that I'm allowed covers this instance. So, for example, I thought the footpath was clear and there was a child that suddenly ran into the road. And so I swerved off the road and drove onto the footpath in order to avoid hitting the child. And so therefore I should not be convicted, okay? That's how to read this from the bottom two boxes up to the top box. So it's a justification for that box labeled A. And you could see that there's going to be what's called a rebuttal. There's an attack on the conclusion where somebody else says, no, actually, the circumstance is one in which, in effect, you should be convicted of the offense of driving on the footpath. And then I'm going to give you my reasons. The first one is that the traffic was moving slowly, so probably you had a chance to stop. And The other point is that there was plenty of room to maneuver on the street. That's the counterclaim, right? That's the way that an adversarial system would work. Claim and counterclaim, and each of the claims and counterclaims has their own justification here. This is an instance in which classical logic cannot work because there's a contradiction between the propositions. So the argument can develop further, right? So you can have this kind of growth of this kind of decision tree on both sides. Somebody, and again, in an adversarial context, there's attack and counterattack of certain parts of the overall argumentation here. So somebody comes back and they say, well, you said that the footpath was clear, that is C. I say that the footpath was not clear, and I say that, and I give my justification as E. A witness saw 3 children on the footpath drawing with chalk. So the footpath was not clear. Okay, so that's my counter argument to the claim that the footpath was clear. And if you think it through, if it is false that the footpath was clear, then the conclusion that I draw that I should not be convicted should not follow. I kind of removed one of the premises that supported the conclusion, and therefore my conclusion doesn't follow. Okay, so you're trying to undermine each other's positions. We build this somewhat further. The driver claims, that should be a solid arrow. The new one. So D, the driver claims that he saw no one on the footpath. Okay, and if the driver claims he saw no one on the footpath, that implies the footpath was clear. And the idea here is that the driver can only go on the basis of their own perception. From their point of view, the sidewalk was clear. And so, if you were doing a bit of forensics here, you would have to go and try to investigate, what was the point of view of the driver. Maybe there were children on the sidewalk, but maybe they were hidden underneath something or obscured by, some other means. So you could have this counterclaim, right? So, and then we can build it further. So somebody wants to say the driver's claim that they saw no one on the footpath, so therefore the footpath was clear, can't possibly be true because the sun was in the driver's eyes. And so this reasoning from what the driver claims to what was holding can't be the case. It's an attack on the application of a rule. And the support behind this claim is that the sun was setting and the car was driving directly west, uphill into the glare. So the driver's eyesight was being blocked here. So this is an attack on an inference. And we can then also go to the other side and attack the other side of the argument, one of those premises. So there was a claim there was plenty of room to maneuver on the street. And somebody says, no, there was not plenty of room to maneuver on the street. And you notice that this is defense of the person who's being accused, right? Because they're giving a justification for why they couldn't maneuver on the street, right? So that they could not maneuver on the street. Why is that? Because there was a car driving up quickly on the right side, so they couldn't swerve over to the right side of the street. And furthermore, there was a car tailgating behind the driver, so that they were feeling forced to continue to progress straight ahead. And rather than going to the right and swerving across the street, or rather than suddenly stopping and having somebody crash into them from behind, they thought that they would swerve onto the footpath. So you see there's this whole construction of arguments and counter arguments that you can draw. So then the next step that we have is we abstract. This is where we move from the instantiated argument to the abstracted argument. We abstract these arguments to say we're going to kind of cluster them together into units. Argument A is one unit, argument B is another unit, argument C is another unit, argument D, and argument E. The reason why we organize it this way is because these units have attack relations, those dashed blue lines between them, signaling that something in one argument is attacked by something else in another argument. So we draw circles around these kinds of units. And from this, we go to this move of abstract argumentation, where we're no longer looking inside the nodes. These are abstract. We don't really look at the content anymore. We only look at these as if they are atomic objects. and the arrows between them are representing attack relations. And this abstracts from the content and abstracts also from the notion of contradiction to just reasoning over these graph relations. And we reason as follows. We have these ways of calculating something being in and out. We don't need to worry terribly much about that. But if something is not attacked, there's no arrow pointing at it, you are in. So C is in, it's colored green because nothing is pointing at it. There's no attack on it. A is out because C is in and C attacks A. We also know that since A is attacking D, but A is out, that we allow D to be in because there's now nothing attacking D. That is, the thing that did attack D, namely A, has been basically kicked out of the game, right? And now we have two choices about B and E. Either you can select B first, say that's in, and that attacks E, so E is out, or you can make the other selection and you can select E, so E is in, and E attacks B, and so that means that B is out. And so you have these two what are called preferred extensions, that is, sets of arguments that hold together without any attack and without any inconsistency between them. So we've got these two extensions. How do you decide? Well, there may be various preferences and interpretive rules that come into play at this particular point. So let's talk very briefly. Actually, somebody should remind me of how much time I've got, but I have just 2 more points to go through about this, but let me just hear from Juliano.
Adam, we have already exceeded the time, but you may go through these points.
Okay, so let me I won't spend much time on this. There's a whole discussion about argumentation schemes where, for instance, you have, let me do this one, expert opinion, where you have a pattern of reasoning that's very often used, for instance, in court. We have an expert witness, but what you know in an antagonistic context, that there's a cross-examination in effect of the witness. You're asking, are they really a witness? Are they really an expert in the domain? What's their status and these kinds of things? So argumentation schemes are another pattern of reasoning. And the other thing that there are many other legal argumentation schemes. And then we can also talk about rule preferences that hold between rules. And this also may be another way to sort of determine which is a winning argument. That is, it's a winning argument when the rule that's being applied has satisfied one of these preference rankings. And there's also a related notion of standards of proof that are also tied to abstract argumentation. And there's a lot more about argumentation that I certainly won't talk about. And that's it. Thank you very much.
Thank you very much, Adam, for this introduction to the subject of argumentation logics and argumentation systems. There is one question from the audience, which is if there is any practical implementation, computational implementation and application of these argumentation systems.
Depends on how practical you mean is practical. Not yet really. There had been various efforts over time to make practical tools. One tool was called Rationale. And you can also find these sorts of tools available for teaching reasoning in schools. So it's not just for legal practice. One tool is called Rationale. They had a commercial product. You could make beautiful graphs, relate them to text. And the problem is that it takes a lot of work to create one of these argument graphs. And as I'm sure you could imagine, if you have a legal dispute, these argument graphs can become very large, very quickly, and very complicated. And they take a lot of effort. And the question really was, what is the added value given the work that you have to put in of the argument graphs? There have been other efforts to apply this, to use argument graphs in legal contexts to present the structure of arguments both to the judge and also to the jury, because it kind of makes it a lot clearer. And again, there's a lot of work that has to be done. So the challenge for argumentation in this, using these kinds of graphs, is to develop tools that facilitate the transformation of an argument from the source, whether that's an argument in court or whether that's an argument extracted from text, into an argument graph, so that it's the creation of arguments is much faster. So it hasn't been successful yet. The inspiration is clearly there, the use case is clearly there, and people are doing a lot of work to find this way to facilitate the creation of argument graphs from source material.
Thank you very much, Adam. I now move to Professor Burkhard Schafer talk. So Burkhard Schafer is Professor of Computational Legal Theory at the University of Edinburgh. He's co-founder and currently director of the Script Center for IT and IP Law, where his work covers all aspects of technology regulation. He's also a member of the expert group AI for People, which is a cross-border initiative chairing the working group on an ethics framework for legal technology. Please, Professor Burkhard, you have the floor now.
Thank you very much, and thanks a lot also from me for your kind invitation and this excellent event. I'm indeed going to talk a little bit in the next 20 minutes or so about the work we've done with AI for People, but also with the new research network on trusted autonomous systems. And I'm going to share my screen in a second. Okay. And start time. So, one of the remarkable things, and veterans like Adam and Monica, I think, will agree with that, is that over the last couple of years, the uptake of legal tech and legal AI has accelerated massively. For a very long time, it was a sort of niche interest primarily for academics. There were a number of success stories, but the sort of broad acceptance by the legal community was something we always aimed for, but were difficult to realize. And now it looks indeed as if the availability of AI tools is going to change the way legal services are delivered. This is a chart from a study carried out by the Law Society of England and Wales, simply trying to quantify what impact already now technology has on the job market for lawyers. And it does seem, even though these have to be taken with a grain of salt, that there is a markable, quantifiable impact now that, for instance, jobs are not created in the same speed that they had been in the past. And that poses a challenge for law societies, for regulatory bodies in particular, on how to respond to that development. One of the things we did in Scotland, for instance, is to create a new accreditation of legal technologist, someone who specializes in legal technology. And for the first time, this accreditation by the Law Society is available both for lawyers, but also for non-lawyers, for IT specialists working in a law environment. And part of the reason for that is to ensure that citizens get services that are up to scratch, that there's a regulatory environment created that protects all citizens who are the subject of these developments. Historically speaking, always was for a very long time a regulated profession, and that included specific ethics guidelines and regulations to which you have to abide to when you are. Software design, software development is not a regulated profession, and that, I think, does create a number of concerns if we are talking about the widespread adoption in practice. So that these are green shoots of trying to re-establish a degree of regulatory control. Now, Atomium, the European Institute for Science, Media and Democracy, has over the last 3 years run a couple of expert hearings and expert committees trying to develop a framework for the ethical use of AI. I was part of all three. In the first incarnation, the first iteration was shared by Luciano Floridi, whom you can see there on the right, and it tried to come up with some very general principles of AI for a good AI society. The second iteration, shared by Ugo Pagallo, was concerned with a more analytical, slightly more in-depth analysis of the risks. And we are now in a sort of third iteration that looked at ethical rules for specific domains. So the first two reports that we did addressed AI in general. The next round identified 7 sectors that are particularly affected by AI, and that includes law, and I was chairing that specific stream. You can already find the reports from 4 of these streams on the website of Atomium. Unfortunately, not yet the one for law. We were a little bit late. The complexity of our task was greater than we had anticipated. So we are going to present our report in October to a meeting, hopefully. It will then be available also from this website. It also means that I can't give you yet any information about the final report. That would be unfair to our sponsors, but I will base my talk on the work that we presented for the first time in December in an open meeting in Brussels. So there will still be some changes between what I've presented today and the final report when it is given officially to the Commission. These studies already have informed policy initiatives. They informed and were quoted by the high-level expert group on AI by the European Commission, and they also found their way to a certain extent in the proposed new rules on EU regulation on AI that was published a couple of two weeks ago. So some of these ideas are now turned into a regulatory framework, and that is already for me both a delight but also a problem, because it raises for us the old philosophical question of the relation between ethics and law. These things now become law. Are they still an ethical guidance? And principally, I would say, and we have to be very careful, I think, in this space, ethics is not a replacement for regulation. Ethics starts when you have already achieved compliance, and that includes data protection law compliance, but also other duties such as the public sector equality duty. So some of the issues that Monica raised in her excellent talk about the black box society, the danger that we are getting biased AI decisions, for me that is not even an ethical question. That is a strict legal question. These things are illegal, and that is very much how the European Commission proposal also treats them. Ethics starts when this compliance has been achieved, when we want to go above and beyond the call of duty. So that is important to remember. Having said all that, the legal profession is special because for the lawyer, ethics gets teeth. Most lawyers are regulated by their professional bodies. They typically have ethics guidelines, and if you violate these, you can get debarred and excluded from your job in extreme cases. So here we have a sort of in-between model of governance, which is not quite legal regulation, which is not quite just soft ethics guidelines, but professional ethics standards that have a degree of self-enforcement attached with them. And my hope would indeed be that some of our proposals for AI ethics in the law find their way into these professional standards. We came up with around 20 principles, and I won't be able to talk you through all of them, but that one here follows in a way directly from that idea. Making the decision to choose a AI tool is in itself an exercise of professional judgment. And therefore, as members of a profession, lawyers have a particular ethical duty to make that choice responsibly. They have to know what they are doing, just as they have to know this with any other tool. So ignorance is not an excuse if you choose as a lawyer to avail yourself of a tool that then makes a mistake, saying, I didn't know, I couldn't anticipate that, no one told me, it was all complex technology for me, is just not good enough. It also means that as lawyers in a professional organization, we have duties that go beyond the interaction with an individual client. Lawyers are also officers of the court. Their professional bodies take on specific responsibility for the well-being of the legal system as a whole. And that also has ethical consequences. It means in particular that the ethically sound use of AI is a collective responsibility, not just an individual responsibility. And one concrete recommendation for that is, for instance, to have a system in which lawyers can share experience about problems, where there is a systematic whistleblower infrastructure, just as we have in a way with drugs and medical products, so that errors can easily be spotted and encountered. That is indeed one of the recommendations that you also find in the EU regulation for AI, that we need a robust system where people can own up to their mistakes and allow others to benefit from them. There's always a danger to be fascinated by a modern technology. And one of the things that always struck me is firstly that some of the types of technology that we are now talking about have been around ever since I got interested in the field, and that was back in the 1990s. And some of the ethical problems that we now encounter also are quite old. They are not new problems. And a case study I often refer to in this case is one of fully automated legal decision-making, which in the UK was introduced in 1998, so quite some time ago, in the Social Security Act. The Social Security Act allowed fully automated decision-making about social benefit applications, a strictly example of symbolic legal AI. The Security Act is represented as essentially a prologue program. The expectation was it makes decisions faster, cheaper, and potentially also fairer. And if we look at the debate at the time in Parliament, which was very controversial, we already can identify some of the recurrent ethical questions that are still very much with us today, and I think a perennial ethical question. The first one is, how do we know that the decision is right? Is there a problem of the black box society that Monica mentioned? And if it is not right, how can we contest the wrong decisions? What are the remedies? If I develop a tool, I take on a responsibility for when it goes wrong, so I also have to think about potential remedies in that case. So that is one set of problems. Can we make sure these things work? The second one was, even if they can prove that they are correct, even if we have a formal proof of that verifies certain types of characteristics we are interested in, how can they be explained to the claimant and also to the wider society? Now, what Monica was talking about in terms of the black box society covers parts of it, but only parts of it. Explanation in law goes beyond showing how a system worked objectively. It has to take into account what the function of that explanation is. We owe ethically a duty of explanation to a defendant in a criminal trial, which is very different from one in a civil litigation. We owe a duty to explain the law to wider society. Court decisions have multiple social functions, and we have to ask ourselves, how does this task to explain and to educate, even if the system is provably correct, survive when we move to technology? And then there was a third discussion at the time in Parliament, and that is for me in a way the most interesting one. Even if we assume that we can prove that the AI works correctly and replicates faithfully what a human lawyer would be doing, and even if it was able to also explain that decision in an appropriate way, is it ethical to use it? And parliamentarians at the time were not sure about that, not at all. And the concern they had was to say, what symbolic message does it send out to the most vulnerable people in our society? People who apply for social benefit, who very often are already at the margins, are already facing exclusion, if we tell them, we are not even interested enough in your story to give you a human to tell it to. Here's a form, fill it in, it will automatically calculate what you are owed, then you get your money. Then you should be happy, shouldn't you? And I think some parliamentarians quite rightly said it's not that easy. Using this on one particularly vulnerable group and only that group is also sending a symbolic message. Being faster, being cheaper are important characteristics, but we also have to take into account the psychological impact that this has on humans and the wider social impact and our understanding of human dignity. If you look at the discussion today, and also I would say the contribution the AI and Law Society has made to it, I would say the first one was always with us and always a key theme in AI and law, and we have made definite progress there. The second one is a big topic at the moment, and yes, there are technological answers to this. Interpretable AI, explainable AI is a hot topic. But these are all technical problems and technical solutions. I think we've shied away very often from the harder questions, the questions that do not have obvious technical solutions that question number 3 encompasses. What is the wider social message that we are sending out if we automatize legal decision making? So we came up with 20 principles and might even have more. And as I said, I won't be able to mention them all. But the important underlying philosophy was that law is special. Law has a specific type of importance for our life that other fields where we might think about automation don't. It is constitutive for our society. We want to live in a democracy under the rule of law. And the rule of law ideal is not just a technique. It creates a specific type of collective identity, evolves over a long time, and its practices and forms are imbued with social meaning. There is a reason why our judges wear fancy dress, like the one in the picture above. It sends a specific type of symbolic message that is important for the dignity of the justice system. The image below, that is the famous Miller from Swansea, a simple miller who challenged Frederick the Great and said, as long as there are courts in this country, I can have my mill and you can't take it away from me. And that type of story creates identity. It allows a democracy, a country, to explain what it is. And we have to be really, really careful what we do with this type of social meaning when we replace it by machines. So we tried in these 20 principles to capture some of the opportunities for AI for better justice and for the rule of law, but also some of the risks. What we want is a 360-degree assessment of the impact that AI has on the integrity of the legal system and of its values, both the ones that are obvious and the ones that are maybe less obvious. And yeah, simply because of time, I'm just going to talk very little bit about some of them. One of the interesting things about law and legal AI is that sometimes systems that work well for your client and even well for the state at a given point in time can have in the long run problematic and undesirable ethical consequences. Take an AI that predicts the likelihood to win a case. That can be really beneficial if it works well, because your client won't litigate if it's unnecessary, they won't spend money, they won't lose money, they don't lose their time and effort. So it might be of benefit for your client to have a better assessment of the chances to win a case. It works also for the justice system. It reduces costs, it reduces frivolous litigation. These are good things, and they definitely count from an ethical perspective. But in the long run, there are concerns and dangers associated with this. It might mean that certain types of cases aren't heard any longer. And Adam, in his talk about argumentation schemes, he mentioned one of the problems in law is that the law sometimes changes. Precedents are overturned. Laws are changed as a response of social pressure. And very, very often, the reason for that is that someone took on a case that looked totally hopeless and nonetheless won it against the odds. Some of the most important changes that we have in the law came from unexpected cases by our Supreme Court, by the constitutional courts. Would they still happen if an AI says you have no chance of winning? Would they happen if a legal aid board uses this technology to say, if you only have that low a chance, we are not going to fund you? So even though it might benefit your individual concrete client in front of you, and even if it might benefit the legal system at this point in time, there might still be a cost for the long-term legal system and for the common good in living lawfully, because we are ossifying potentially our legal system. So we need a way to account of these long-term dangers just as much as we need to be able to ascertain the correctness of the system as it is now. And that brings me to the second most important principle, and probably the only one that we will have time to discuss. Legal technology is shaped in context with significant power imbalances. And that means in particular that the responsible development and employment of AI reflects these structural conditions and protects against unfair redistribution of risk and benefits. And ideally, AI in law should aim to reduce existing power imbalances. One key theme of the legal AI community always was access to law, facilitating access to law, making it more accessible to ordinary citizens. And that is a challenge to power, potentially. But as AI becomes more important and more successful, we are also facing the danger that new data silos are created, walled gardens, that the law of the future is owned by LexisNexis and Westlaw or Thomson Reuters, because they are in charge of the AI retrieval tools that some of the speakers already mentioned, because they generate or they own through copyright quite a bit of the data that trains these models and makes them feasible. So potentially we have to be very, very careful that the potential for AI to create a fairer society and a better access to justice does not in reality have the opposite effect, because it creates new ownership structures for legal data. We talked a little bit about natural language processing also in the first talk, the overview talk. Here too, we can quickly start to think about power and power imbalances. Language is still a significant barrier for the access to justice for many. Legal language is complicated. Can we use AI to make it more accessible, to translate authoritatively into easier grammatical structures? But if we do that, is it good enough to follow or to work with languages for which we have robust language models, because there are lots of speakers? If you're an English speaker or a Spanish speaker or a Chinese speaker, there will be lots of people who work in that field and might develop tools for you. If you're a speaker of a minority language, Gaelic, Scots, for instance, or in one of the indigenous languages in the South Americas, will there be similar tools available? I think ethical legal AI has to take these structural concerns into account and cater for them. So we should not just do what is easy for us and cheap for us and what everyone else is doing because there is a market for it. We should lobby for, and we should be engaged and give a voice to attempts to use the full potential of legal technology in that way. So as I said, I won't have time to go through the other principles at this point, but it gives you hopefully a flavor of what we tried to do with AI for people. We tried to find a way to evaluate the legal balance of technology in the justice system that goes beyond what we have been doing in the past. And that was primarily to try to make sure that systems are correct, that they give reasons, that they are unbiased, things that are relatively easy to address with technological solutions, and instead open the discourse to those things that were already raised back in the 1990s, the wider social impact and the significance that automation can have for our justice system. And yes, the other 18 principles you will be able to read from October onwards, hopefully, on the AI for People website. Thank you.
Thank you very much, Burkhard. We have a question from the audience, which is in the AI for People group, you have selected some sectors for a particular attention and for developing a work or paper on that. And the question is, what are the most critical sectors in the opinion of the AI for People group, or in your opinion, and why? This is the question. Yep. What are the most critical sectors and why?
Mm-hmm. Well, there's a reason I volunteered to chair the legal stream. I do think the legal stream is one of the most important ones, and one of the most risky ones as well. If the rule of law fails, then our societies face a massive problem. And I think we've seen over the last couple of years that we can't take the rule of law for granted. We have seen in seemingly mature and stable democracies how politicians were able to bend the rule of law in ways that no one could have anticipated, I think, 10 years ago. So I think this is a precarious public resource that needs protecting. And for me, that's why I think it matters here in particular. And that's why I brought the example back from 1996, which I think was a good discussion to realize the way we treat the most vulnerable in our society, how social benefit law works, how a whole range of legal provisions works. That is absolutely crucial for a just society, and we have to be very, very careful how we do this. The second important one is in the financial sector. Obviously, there are concerns that quite a number of the problems that we faced in the financial sector, including the 2008 crash, were at least partly caused by inadvised use of technology, high-frequency trading, using algorithms for risk modeling when no human any longer understands these risk models. That again creates risks for all of us. Again, if our finance system crumbles, if the banking system fails, I don't think our societies can any longer cope with that. So these two on the civilian side were for me the most important, and they were two of the 7 themes that were discussed by the panel.
Thank you. We have another question here, which is if AI may reduce frivolous litigation, and what might be ethical concerns about that?
Yeah, I mean, as I said, I mean, it's helping people to plan better whether they should sue is in principle a good idea. And I don't want to take anything away from these approaches that got quite a bit of press that try to predict the outcome of cases. So there's definitely a plus there. The only question is it enough to now stop and say, well, that's obvious then, we don't have to worry any longer. And I don't think it is. And I try to give a little bit of the reason in the talk, but I can illustrate it through an example. Back in, I think, 1996, if you had asked a lawyer, a judge, a legal academic in Scotland, can a husband rape his wife? They would all have said no. They would have said there is a institutional writer, Lord Hume, who said it is not a competent charge. There are at least 3 high-level precedents that have reaffirmed that principle. Look, in any textbook of Scots criminal law, it will tell you there is no rape within marriage. The prosecutor at the time, like Procurator Fiscal, nonetheless brought an action against Stallard on the grounds of having raped his wife. Any human lawyer on the eve of the trial would have said, you made a mistake. That's crazy. You have no chance in hell. This is totally frivolous. You are wasting the court's time. But he said, no, actually, I think there is something going on in our society. I'm sensing here a shift in mood. I think I can convince the court to deviate from past precedents. And he took that risk. And lo and behold, he was successful. And he changed the law through one momentous case. If you had asked a human lawyer, they would have said no chance. If you now use these human lawyers to train the AI or to validate the AI will give you the same answer. It will say no chance. So far, that is still not bad, because you can simply treat it as one other piece of advice as you would treat the advice from another human lawyer. But if you then start to trust the AI more, because it's an AI, it's a computer, it can't make mistakes, then you have a problem, because then you stop taking that long shot. Or even worse, if it is used by low-ranking bureaucrats to decide on funding. That's my concern about it being used by legal aid boards. They will simply say, no, sorry, this is not worth public money. The AI says you have no chance, we are not going to fund you. So if that system had been in place, we risk that this type of landmark decisions, the decisions that deviate from the past, that change the trajectory in response to social needs, are not heard any longer, because the AI lacks the sort of social context. One key assumption behind machine learning is the past is a reliable guide to the future. Often it is. In law, we have the principle of binding precedents because of that. We want stability as well, but it's not the whole story. Sometimes the past becomes an albatross around our necks. And there's a real danger that AI takes away the flexibility or reduces the flexibility that we also need in our legal system.
Well, thank you very much, Burkhard. We are already ahead of time, unfortunately, because I really was having a lot of fun, and I had today. And I would like to thank all the participants, and I'd like to thank Professor Burkhard Schafer, Professor Monica Palmirani, Professor Enrico Francesconi, and Professor Adam Wyner for their brilliant talks. This was meant to be an introductory event and preparatory for our main event this year here in Brazil, which is the ICAIL from June the 21st to June the 25th. And so I hope that the participants here will also join to check out what is going on in the mainstream of these different fields from which we had today the main experts in their particular area of knowledge. And so I would like to thank again our sponsors, Jus Brasil, Legal Code, Logarithm, and Urbano Vitalino Advogados. And I hope to see you all in the ICAIL conference in the end of June. Thank you very much, and see you.